Hey, Maximizers, Kevin here. With me today is Jared Stark of Stark Business Law. And Jared's going to be here to answer some questions and give some tips, I guess we won't call it legal advice, so to speak, but just some general tips with making sure that we're compliant with laws and intellectual property and just some general thoughts to consider whether you're just getting started or you have an established business and you just want to make sure you're doing the right things. So Jared's a great resource. Actually met him because of Seller Summit going to last year. And I've actually worked with Jared on a couple different things. So Jared, I want to go ahead and just kick it over to you. If you could just introduce yourself a little bit and give your legal background, so to speak.
Sure, sounds good. Well, I appreciate it, Kevin. So the standard legal disclaimer applies today. I'm happy to give advice and general informational sort of resources to everybody. But if you were listening to this, I hope you get some great information. But I'm not your attorney, so there's no attorney-client relationship. So this is all for general educational purposes. With that said, I am a startup attorney. I work primarily with people who are starting or running businesses in either the e-commerce space or the tech space, so all across the board, and generally help people with all the corporate stuff. So I don't do the fun courtroom stuff that you see on TV, but I do all of the behind-the-scenes work. So helping you form companies, protect your intellectual property like trademarks, negotiating contracts with vendors and suppliers and employees and all that good stuff.
Okay, so you kind of do the gamut of business law, so to speak, without going into the courtroom.
Exactly. So everything on the corporate side, that's pretty much what I handle.
Okay, cool. And I didn't mention it earlier, but basically, for those watching this on YouTube, Jared's kind of calling in, so to speak, on this line. So unfortunately, we won't be able to see Jared's face on this, but you can tell his genuine sincerity in how he talks. So just getting started into a couple of the questions here. What is the whole point of setting up an entity for your business versus being like a sole proprietor?
Sure. So this is a great question, and we get this a lot. When you are looking to start a business, oftentimes you want to test the waters, and you don't want to spend money unnecessarily, especially on a lawyer. It's sort of the last thing you want to do in the beginning when you're looking to start a business. So a lot of times people will sort of tiptoe into it, and they will start selling a product or a service, be it online or elsewhere, through their own name, just with either a fictitious name or through their own name as a sole proprietor, just to see if there's a market out there, to see if their idea has legs. And it's tempting, but there are some risks there. I generally advise people not to do that. Forming an entity can be fairly simple. There are, and we could talk about the differences, but there are, a number of entities. Most popular for a business like that, an e-commerce sort of business, is either an LLC or a corporation. And really the benefit to doing that in the beginning rather than being a sole proprietor is that you're eliminating or at least greatly reducing any sort of risk to your personal assets. So if you're selling a product, even if you just feel that you're testing the waters, you're just seeing, doing a sort of a market study, there's always a risk that even if you sell just one product, that one person might get hurt. And if they do, and you're selling it as a sole proprietor, you're selling it personally, the liability falls on you. They can potentially sue you for damages if they get hurt, or if something happens, or if a third party gets hurt. If you're doing it through an entity that you've set up, either a corporation or an LLC, typically in most cases, their only recourse is against that entity. So your own personal assets, your bank account, your house, everything tied to you should be safe.
Okay, so the entity is almost like a person in a sense.
Yeah, exactly. That's a really good way to think about it. So, and legally, entities are pretty much treated like people. They can be born, they're created, they can die, they're dissolved. They can sue other people, they can be sued. So it's a stand-in in a way for you. And it is treated legally like a person in a lot of respects.
Got it. So basically it's one of those things that if I was a consumer and I'm buying uh, Jared's product. Not that I don't believe you sell directly on e-commerce, but if I was buying your e-commerce product and you had an LLC, if I had to sue for whatever reason, I'm suing the LLC, not Jared personally, right?
Exactly. That's the idea. Now, there are, like everything, there are pitfalls and there are ways to lose that protection.
Okay.
But generally speaking, if you're doing everything right, then yes.
Okay. Well, let's start at the beginning of it. So if I'm setting up an entity, which let's just say like I'm getting started and I need to set up an entity, or I've been operating as a sole proprietor. Like personally, I operated as a sole proprietor for a couple months when I first got started to test the water, so to speak. Either way, what do I need to do if I want to get an entity, and what are the different entities, and what are the kind of pros and cons of them?
Sure. So getting an entity is fairly easy. You can work with a lawyer. I help people set up entities all the time.
Mm-hmm.
There are also, as I'm sure you've seen, these online document filing services like LegalZoom that'll set them up for you. Generally, I'll just say it's not just because I have a bias here, but it's generally better to use an attorney to set it up because it's going to be set up right and it's going to protect you the right way. But the process is fairly straightforward. You have to pick a state, and then you can form the entity in that state. There are different reasons people pick different states. You've probably heard a lot about Delaware, for example.
Right.
But to sort of make this, take it from the beginning and make this really a high-level overview, you pick a state, you form the entity. The whole process in most states takes a couple of weeks at the most. Filing fees are typically not that much. Most attorneys set these up fairly inexpensively, so it's not a huge startup cost. Now, when determining how you're going to do this, like you alluded to, there are a couple different entities. And in some states, there are tons of them. There's corporations, LLCs, general partnerships, limited partnerships. There are now hybrid entities that are for profit, but they have charitable purposes. So there's a wide variety. But again, keeping it simple, for 99% of people in the e-commerce space who are either working by themselves or maybe with just one partner, either an LLC or a corporation is really best in most cases.
Okay, so it's basically the simplest to form, and you don't have as much documentation, so to speak, as like if you had a C corp, right?
Well, so for an LLC, yes. An LLC is really flexible, really easy to set up. For a corporation, there are different types of corporations. So there are C corporations, there are S corporations. These refer to provisions in the tax code for their tax treatment. Generally speaking, corporations, you've probably heard this. If you've done any research online about setting up an entity, you'll generally hear the advice that corporations are more cumbersome to run. There's more documentation involved.
Mm-hmm.
That's I hate to paint with a sort of sweeping generality here, but I guess that's usually true. Corporations tend to be more complex. There's a board of directors. Shareholders elect the board. There have to be regular shareholder meetings. So yes, corporations more complex. An LLC, by contrast, was created to be more flexible. So there's less of a requirement to have those sort of regular meetings. There's no board of directors. So an LLC can be a really nice option for someone who wants some liability protection, wants some of the tax benefits associated with it too, perhaps, and doesn't really want to be bothered with figuring out how to set up a board of directors and holding board meetings and doing the whole the Gordon Gecko thing.
Yes. So, and I know you're not an accountant or CPA, but in a very broad stroke, general explanation, what are the different tax treatments, so to speak, of like a corporation versus an LLC, or in the middle there's the kind of C corp, or
Sure.
sorry, S
So
corp, I think I meant.
yes. So additional disclaimer to my previous disclaimer:
Right.
I am not not a CPA or an accountant. So
Right.
before you do anything, you should always seek the advice of an accountant to make sure that it's
Yes.
right for you. That said, the general tax treatment is like this. An LLC by default, if you do nothing to it, you just form a plain vanilla simple LLC, is considered a pass-through entity.
Okay.
So and it's in keeping with sort of its simple structure. So
Hmm.
everything about this is simple. It's easy to set up, and the tax structure means basically any profit that the LLC makes will go onto your personal tax return, basically.
Okay.
So 100% of the LLC's profit will just be reported on your personal taxes when you file taxes at the end of the year if you are the sole owner of that LLC. The
Okay.
LLC doesn't pay its own taxes. Um, it does file an informational tax return at the end of the year, just stating, the income that it's made, but the LLC itself doesn't pay taxes.
Hmm.
It just gets passed on to you, which is nice for a lot of people who are running a small business. And I don't necessarily mean small by revenue, just small in terms of the number of shareholders and moving parts.
Right.
So you don't have to have an accountant do as complicated of a accounting for a pass-through entity as you would with a C corporation. So at the other end of the spectrum, you've got a C corporation. This is what most of the Fortune 500 are. So most large companies are C corporations because there are a number of reasons, but one of the big reasons is if you're in a situation where you're looking for investors in the future,
Hmm.
much easier to structure investments in a C corporation. So
Mm.
publicly traded companies tend to be C corporations. Large companies with multiple shareholders and outside directors are C corporations. So a C corporation, you've probably heard the double taxation adage. That's where that comes into play.
Right.
So C corporation pays its taxes every year at the corporate tax rate. So there's a corporate tax rate. A C corporation files a tax return. It pays taxes on the profit that it's made, and then if it distributes money to you, so let's say your C corporation made $100,000 this year,
Hmm.
it's going to pay taxes on that $100,000, and then it retains some of the earnings and it distributes another $60,000 to you. So you take your $60,000 dividend out of the corporation,
Hmm.
you then pay taxes on those on your personal tax return. So that money is going through essentially two sets of taxation.
Got it.
Um, this sometimes makes this less attractive for people who want to keep it simple and are just sole owners who plan on taking all of the money or most of the money
Right.
out of the business anyway.
Right. Okay, that makes sense. So it goes back to things generally, or I'm sure generally is the right term, but are generally simpler with an LLC than a corporation like a C corp.
Yeah, exactly. I think that's a great way of putting it. It gets complicated because you can make different tax elections. So when you form an LLC, you can elect to have it treated as an S corporation or a C corporation. When you form a corporation, you can elect to have it treated as an S corporation or a C corporation. So it gets sort of into the weeds there. But generally speaking, LLCs give you the flexibility to keep it simple. And if you do nothing, if you just form it and don't do weird tax elections,
Right.
it's going to be very simple.
Okay. Now, if you start an LLC, and forgive me if you already mentioned this, but if you start an LLC, you can always change it to an S corp or a C corp later if you wanted to, right? If I
That's
understand.
correct. Yeah, there's a little bit of a lag time.
Okay.
Usually, depending on when you do it, it comes into effect the following tax year. But
Got it.
uh, but yes, you can always switch between entity types or between taxation types.
Okay, so it's not like you're locked in. So if you're like, oh my God, I can't start because I got to make sure everything's perfect, you can always do something and change if your needs change, basically.
Right, exactly. And you can also convert entities, which is a little bit clunkier, but I've done that for people. So people who have started LLCs
Hmm.
when they were the only shareholder and they were starting out and it worked great for them, but now they've gotten to the point where they're looking to bring some investors on board and maybe put together a board of directors. So they've
Okay.
actually converted the LLC to a corporation. So that can be done as well.
Okay. Okay. So there's you're never locked in 100%,
No, no.
but it's probably a good idea to seek the advisement of an attorney, I would imagine, because it's probably relatively complex to start making changes.
Yes, before you do anything like that, you should speak to probably both an attorney and to your accountant because it may not comport with your tax minimization strategies. So
Right.
if your CPA is has this plan in mind to minimize your taxes every year, and then you throw it for a loop because you create an entity type that kind of baffles them, that might not be the best. So generally, before doing this, you should speak to your accountant and then speak to an attorney to help you set it up as well.
Yeah, and then that makes sense because I mean, if you think of it like if you have a team and your accountant's part of your team and your attorney is part of your team, you know, the wide receiver and the quarterback have different responsibilities in the field, but they're still trying to get you to the same goal. But you don't want to think too much about one's duties over the others because it's a team concept. You're still trying to get to the same goal. So yeah, it makes sense to speak to both.
Exactly.
Okay, so let's say I've structured an LLC and I've started out and my business has expanded and now all of a sudden I've got multiple brands. Should I create a different LLC for each brand? Does it make sense to do that?
Yeah, this is another great question I get a lot because it gets expensive to do that, and you've got more record keeping. You have to remember to file your annual report every year in each state for each LLC. So
Mm,
it gets a little clunky, but general advice I give is yes. All things considered, if you are able to, it is better to create an individual sort of LLC or company of any sort for your different product lines if you are in the e-commerce space.
okay.
The reason is, again, it goes back to liability. You've got to think about how this liability works. We've talked about if you form an entity, you are hopefully sort of containing any liability within that entity so it doesn't spill into your personal life. Well, that also works for your other products. So let's say that you're selling a couple products on Amazon. Let's say that you're selling something, let's say it's pretty low risk, right? So you're
Right.
selling, I don't know, stationery on
Okay.
Amazon. Okay, so fairly low risk. Maybe someone's going to get a paper cut, but I doubt it's going to become a lawsuit. And
Right.
then you're also selling electronics, and these electronics, there's a cord attached, and there's some risk that one of them could catch fire, burn
Got
someone's
it.
house down. Hopefully not, never happens, but you've got that risk. Now, you're making a great profit from your stationery business, and your electronics business is plugging along. But
Okay.
then disaster strikes, someone's house burns down, and they want to sue the company. Well, it's going to take down your stationery business with it because they're both in the same entity. So if you've suddenly got a $1 million lawsuit filed against your company, and everything is at risk, all the profits from the stationery business, if you have a judgment against that company, everything's at risk. If, on the other hand, you've got two separate entities and you really treat them as separate entities and follow all the rules about that, then worst case scenario is, okay, the electronics business is at risk. It has a judgment against it. It ends up going bankrupt, but at least your stationary business is fine. So all things considered, good idea to break them off into separate LLCs, or maybe you can put a few items or a few brands together into one LLC, but
Hmm.
not a bad idea to at least create some different silos for risk.
Okay. So it goes back to if the LLC is basically separating your personal assets from the LLC's assets, if the assets of the LLC and the two different brands are together, then it's all one pool that somebody could go after. But if you split the different brands into two different LLCs, this one gets sued and has to shut down. This one's still operating. Did I understand that right?
Yeah, that's exactly right.
Okay, cool. Um, so it's all about having this kind of separation of personal or different LLCs potentially. Um, and there's all these formalities involved from what I understand. And if you don't do them right, if somebody takes you to court, they could, as I hear these horror stories sometimes of what they call piercing the corporate veil, I think is what they call it. Or maybe
Right.
that's just a scare tactic. Or maybe
No,
not.
no, it's definitely out there. So piercing the corporate veil, I sort of alluded to this before when I spoke about doing everything right. So this occurs when you have a company that it's generally referred to as piercing the corporate veil, but it works for LLCs or corporations. When you've got a company out there, and even though in theory it is supposed to protect your personal assets, for some reason a court decides that they're going to let someone come after your personal assets instead. They're going to let someone go beyond the corporation in order to satisfy a judgment.
Okay.
So, this generally occurs when you don't follow what you mentioned, the corporate formalities. There are less, and this is again a very general rule here, but
Mm-hmm.
there tend to be less formalities for an LLC, which is another reason people prefer it than
Mm-hmm.
for a corporation. But basically, in most cases, in most states, the court looks at the company and wants to see that it's really being treated as a company. It's really being treated the way a company should, and not just an alter ego for you personally. So
Right.
if you've got a corporation, they want to see that you have bylaws, that you have a bank account. That this is a big one for anyone. Having a separate bank account for your company,
Okay.
having an EIN for your company, an employment identification number from the IRS, really creating that distinct identity for the company, not commingling funds. So your bank account, really you shouldn't be hitting up that corporate bank account, every time you're at Starbucks.
Mhm.
That bank account really needs to be for the company. Um, no problem with taking money out to pay yourself a salary or to pay yourself dividends or distributions. Of course, you can do that, but you shouldn't be using the company account for personal purchases. So, creating an account, not commingling funds. If you've got a corporation, creating a board of directors, holding regular shareholders meetings. It sounds a bit ridiculous if you're the only shareholder. With an LLC, some of that doesn't apply because there aren't shareholder meetings and there's no board of directors. But at the same time, you still got to have that bank account. You've still got to capitalize the account. Can't leave it empty. You've got to make sure you're not commingling funds. The other way this sometimes gets people tripped up is signing contracts. People don't realize that just because they've created the entity doesn't mean that it sort of puts this shield over them.
Mm.
You've got to use it. So if you
Mhm.
create the entity and then you go and you sign a contract with a marketing agency and you sign it personally without signing as the corporation or the LLC, well, now you're in contract with them and they can come after you if there's a problem. So, you know, always signing every single contract in the name of the company.
Mhm.
It would be signed by the company, and then underneath it, by your name, by Jared Stark, president. So you want to make sure that you're doing that. So there are some tricks here, and there are some I don't know if I'd call them tricks, but there are some
Right.
rules of the road that you've got to follow to make sure that your company is actually going to provide you with that protection. And they're not difficult. They're all pretty much common sense
Right.
and easy to do. You just have to make sure that you're aware of them and that you're following them.
Yeah, it's a good point. It's one of those things, from my understanding, it's very easy to do, but it's also easy not to do. And it's not like the corporate Gestapo is going to come out and say, you don't have a bank account. It's going to be one of those things that's going to be brought up in a litigation, right?
Exactly. No one's really actively, policing this for you. No one's looking at it. The state isn't coming around in most cases looking to see if you've
Right.
got a separate bank account. They don't really care if your corporation is active or dormant or what you do with it. It's only once you're in a lawsuit that the other side is going to do discovery and going to do everything they can to try and get at your assets. So that's when you've got to show them that, hey, you can't get around this corporation. It really, it's been following all the rules and it's um, going to limit my liability.
Okay. Now, I've heard this term about making sure you're properly capitalized in your um, bank account. Like, what are some rules of thumb with that?
Yeah, this is a good question. Also, I'm not a litigator, so I don't have I don't know if I have a great rule of thumb for how much to use. I think it would vary widely by state, and I'm sure there's case law in each state. But the problem tends to come when, okay, you've got a bank account and you weren't commingling, but the bank account has $400 in it total. So it's obvious that you're using this to try and shield your liability. I mean, the rule is, you don't have to keep. Generally speaking, you don't have to keep stuffing money into it if you don't have any money, if the company's not making money. But
Right.
you should have a bank account that is, sufficiently capitalized to pay your expenses, to really be a true operating account. I think that's probably the best guidance.
So as long as there's money regularly coming in and going out, and not too much just going out, especially into your own pocket, right? Yeah.
Yeah. And I've seen, again, I'm not a litigator, so I don't know if I can comment on all the case law, but I've seen cases out there where, they basically routinely emptied the bank account. The bank account was kept very, very low, and that was used as a justification for piercing the corporate veil. So you don't want to take every cent out. You don't want to have a bank account that's really just sitting there nearly empty. That generally you want to really use it as a true operating account and make sure that it's funded enough to really continue to cover your liabilities.
Okay, so you basically some good faith effort, and there's no real rule of what that is. It sounds like.
Yeah, good faith goes a long way. That's a good way to put it. Good faith does go a long way. So everything you do should be in good faith, and that'll
Right.
generally serve you well.
Yes, for many reasons, and I'm sure if you're in good faith, just in how you deal with people in general, you're probably less likely to have to worry about litigation and things like that because you're going to resolve things without having to go to court.
Yes, hopefully.
Hopefully,
And
yes.
generally, hopefully, the karma treats you well. So
Right, exactly. But if you don't, then now you've got attorneys and there's a system to work out disputes and stuff like that. But it's good to set yourself up. It's kind of an insurance policy because in my full-time job, I work in insurance, and insurance is all about risk. And in some ways, you're creating an insurance policy on your business by running these formalities the right way, because if something did happen, you've shown to the courts, I guess, so to speak, that you're making a good faith effort to do the right formalities and to operate the business almost as a separate person from yourself.
Exactly. I think you're looking at it the right way. Absolutely.
Okay, good. Well, I want to switch over from kind of the corporate side of things and now get a little bit more into intellectual property. So, one of the big things is on Amazon, if people are looking to get brand registered, you have to have a registered trademark. That's, at the time we're recording this, it's about a year-old rule now. How does someone go about getting their well, actually, before we even get into that, what are some steps you should take to protect your brand?
Sure. So, this is one of these chicken or the egg situations. People form a company and they go ahead and they create a brand that they love, and they don't really know. Oftentimes, they don't research whether or not it is already trademarked or whether or not they'd be able to get a trademark for the brand before forming it. So, one of the things to keep in mind is from the very beginning, you should keep the idea of trademarkability in mind, whether or not the brand that you're creating is going to be able to be trademarked. And this is difficult because there's no way to get a guarantee on this. You can't just call the trademark office and ask them. You've got to, if you file a trademark application to protect your brand, it could take anywhere between 6 or 7 months on the fastest side to over a year to actually get a response. And by then, you're already selling products, and if you've got to rebrand, it's hard. But let me take it a step back before we get into that. Mm-hmm. At a very high level overview, people talk about trademarks, copyrights, and patents. People are often confused as to which one does what. Generally speaking, protecting a brand, that's the realm of trademarks. So trademarks protect brands, they protect names, they protect logos. Anything you're using to identify the source of goods or products, anything you're using to identify your company, that's a trademark. So when you build a brand, the way to protect that from infringement is to get a trademark. Trademark basically gives you a monopoly over that name or that logo in connection with whatever you're selling.
Mm-hmm. Okay. So what is the difference between, people see TM and the R circle and the C circle? What is the difference between all those?
Yeah, that's a great question. So the TM, that means an unregistered trademark. So that is someone who is asserting common law rights over a trademark. So they haven't registered it with the USPTO. There are a number of reasons why this may be the case. It may be pending still, so they're using TM while it's pending. It may be something that's been rejected by the trademark office, by the USPTO, but they still want to try and assert some rights. So a TM is common law. It means it's unregistered. It doesn't really have very much weight. It's difficult. You usually can't enforce it in federal court. You can't often assert it well in state courts. So it's just an attempt, a sort of a last-ditch attempt to assert some trademark rights over a brand. There's no application that's necessary. You can just slap TM on anything that you have a good faith belief is your brand. If you've registered it with the US Patent and Trademark Office, if you have a registered trademark, then you can use the R symbol, the little R in a circle.
Okay.
That means registered trademark. That carries weight with it. If someone is infringing upon your trademark, a registered trademark, you can sue them in federal court and assert your trademark rights. And then the little C, that's for copyright.
Hmm.
So copyright's different. Copyright protects original works of authorship. So these are a book or artwork or songs that you've written, or even the content on your website. Your website content is copyrightable.
Hmm.
So it doesn't protect your brand, doesn't protect the name of your company, but it protects the actual content that you're creating.
Okay. And you don't have to necessarily register to use the C circle, right?
You do not have to register to use the C circle. It's not a terrible idea to register a copyright. So you get, unlike trademarks, you get copyright protection as soon as you create original works of authorship. So,
Okay.
when you finish recording this, today, you've got a copyright to it
Okay.
automatically. But if someone infringes upon it, and if you want to actually enforce it, then you've got to go ahead and register it. But you can use the C even without it being registered. Yes.
Okay. Good deal. So, if I wanted to register the registered trademark and be able to legally use the R circle, um, what is involved with that? I know you said it can be a process. It takes a while.
Yeah, sure. So the first process, the first step before you even get engaged in the process, is to do a trademark search. So you should get with an attorney and you should do a trademark search, which entails looking through the trademark database
Hmm.
and looking through hopefully the internet and common law trademark usage to get an idea for whether or not someone's either already taken your potential trademark
Hmm.
or if someone's got something that is confusingly similar. So that's the
Mm.
standard that the USPTO uses. So your trademark can be rejected even if no one has an identical trademark, even if someone is just using a name that they consider confusingly similar. There are a number of factors they look at. The two big ones are the similarity of the names or logos, so how similar they look or sound, and how similar the underlying goods or services are. So an example that I like to give is Pandora. So Pandora, the music radio, and Pandora, the jewelry store, they both have trademarks. They both coexist, even though they've got an identical name, because the services are so different. One is selling jewelry, one is selling
Oh,
books
gotcha.
and
Uh-huh.
radio. So the USPTO, would say, well, there's no likelihood of confusion here. There's really no confusing similarity here because the goods and the services are so different that people aren't going to assume they're coming from the same source. Um, Now, this cuts the other way too, right? If you are selling under the brand, let's call it let's pretend it's Pandora, and you're selling jewelry as Pandora's box, okay?
Mm.
Now, they probably won't qualify for a trademark because Pandora's box, even though it's different than Pandora, is going to be so similar. And when you take into account they're both in the same space in terms of selling the same goods, you're going to probably end up rejected. So the first step to sort of go back to what I was saying, the first step is to do this trademark search to see what's out there. Trademark attorneys can never give you a guarantee. It's impossible to know, but they can give you usually a pretty good prediction as to your likelihood of success in registering a trademark. So you do that search, you make a decision as to whether or not you think you've got a strong trademark and you want to go forward.
Hmm.
Then you basically submit the application. So you submit an application to the USPTO. Filing fee varies. It is generally speaking either $225 or $275 per class of goods. So the goods are divided into a number of classes based on what they are. So
Hmm.
your filing fees can be as cheap as $225, and they can range up to many thousands of dollars if you're selling all types of goods. You go ahead and you file the application.
Hmm.
And then the entire application process generally takes anywhere between 7 months at the quickest. If there are no problems and everything sails through, 6 or 7 months. And it can go into the years, year
Hmm.
plus, if there are problems. If the USPTO is challenging your trademark or someone else is challenging your trademark, it can be a lengthy process.
Okay. So let's say you get your trademark and they approve it. Um, sometimes if it's a different name than your LLC, you might have to. We're both in Florida, and I have registered a fictitious name, whereas I think in some states they call it a DBA or doing business as. That's different and gives you different reasons for registering them. Is that a fair statement?
Yeah, exactly. So, a number of people. This is a question I do get sometimes. A number of people register a DBA, and they say, "Well, do I need a trademark? Am I protected because I've registered a fictitious name or a DBA? Doesn't that protect me?" The answer is no. The DBA or the fictitious name filing, that is just the state basically acknowledging that you have an alter ego. So if you
Mm,
formed your company, your company is ABC Widgets Incorporated, but that's not really a very sexy brand name. So you want to be known as something else. You can file as whatever your cool brand name is, doing business as, or vice versa, rather, your LLC doing business as whatever that name is, whatever that cool brand name is. So the state is acknowledging that that's your alter ego, but they're not giving you a monopoly over using that name. Either in the state or federally. So still a good idea to go ahead and do the trademark, even if you've got the DBA.
okay, gotcha. But it's probably one of those things you need both, theoretically, if it's a different name than your LLC.
Theoretically, yes. Some states don't really care, but in some states, and in most states, they do. It's usually a good idea to register both that DBA and the trademark. And a DBA registration is usually really inexpensive. I mean, the filing fees are usually in some states $15 or $25, and it's usually a one-page form. So
Right.
no reason not to do the DBA. It's very easy.
Right. Okay. Um, Now, if I'm selling in multiple countries, do I have to be concerned about my intellectual property once I cross the border?
Yes, good question. So I really practice primarily, trademark law in the U.S., but I've worked with international trademark lawyers from time to time on
Hmm.
this because you do need to worry about intellectual property in other countries. The one of the nice things, well, so if you've got a U.S. trademark, it's enforceable in the U.S. It's enforceable against anyone infringing on your brand in the U.S. But if
Okay.
you find there's infringement in Europe or infringement in Canada, it's likely that you will need a trademark in that country. Whether either in the EU or whatever country in the EU that you're looking at, or in Canada or wherever else you're selling your products. The good thing is there's a treaty basically between most countries that makes it fairly easy to register a trademark across borders once you've registered in one of the countries that's party to the treaty. So if you've registered it in the US,
Hmm.
you can usually get an application pushed through fairly easily in another country. But it is worth doing that. So as you expand into other brands, it's worth updating your IP portfolio to make sure that you're covered.
Okay. Well, good. So that gives us a very good explanation of how to protect our own intellectual property. But at the same time, too, other people probably have their own intellectual property that they're trying to protect. And like for example, I remember one time going to New York, and there were street vendors selling different handbags, and these handbags that looked very much like Prada handbags that said Panda instead of Prada. Like, um, that's probably a silly example, but just in general, there's probably people that are trying to protect things, and even if we think we're doing the right thing and um, you know good faith, but still there's pitfalls we should probably avoid. So, are there any things with intellectual property we need to be careful of more on the protection side of ourselves than uh, protecting ourselves from doing something wrong, I should say?
Got it. Got it. Yeah, it's difficult, right? It is difficult because you can't possibly know about every brand that's out there. You can do a trademark search, like we talked about, and that gives you a good idea, so you can see. I mean, hopefully, if you do a trademark search, you or your attorney will say, "Hey, look, there are two or three brands that I think are kind of similar. Let's go ahead and try and register the trademark, but I think there's some risk out there that these brands may find it infringing, and there's sort of a calculated risk you've got to take, but you can never really shut out all of that risk. You know, One thing that you do want to do beyond just, I mean, if just to the extent that you exist, you're going to have some risk that someone's going to think your brand is infringing on theirs. But if you've done a
Right.
trademark search and you've registered your trademark, you're doing what you can on that
Right.
end. But on the other side, you want to make sure you're not using someone's trademarks. I've had clients who wanted to incorporate someone else's trademark on their web page or in their product. They want to say that it's, our product is similar to this other product, which can sometimes be done. There are exceptions to trademark infringement for comparative advertising.
Hmm.
But generally speaking, you want to be really, really careful about using anyone else's trademarks in your products. So, being just really careful about that on your website, policing comments on your website if you've got comments on your website or a forum or anything like that,
Mm.
making sure nothing's coming up there. That's really all you can do, is just try and stay on top of it. Otherwise, there's always some risk, unfortunately, and sometimes you get these cease and desist letters out of the blue from companies that you never knew existed that are that'll claim that there's infringement happening. But yeah, it goes back to that good faith golden rule, I guess, is
Right.
just try and do everything in good faith and create a paper trail that you've done your homework.
Okay, that makes sense. Are there any other mistakes or pitfalls that you see people make, or just things to consider when having a business like a e-commerce business, just to make sure you don't get yourself in potential hot water later?
Yeah, one thing that is, this is maybe not even on the legal side, but on the accounting side, to go back to that, people get in trouble from the accounting side all the time. It gets away from them, right? They get
Hmm.
started selling products, and in the beginning, it's very easy for them to just sort of worry about doing the accounting later. They
Right.
just want to make those first couple of sales, and then hopefully everything goes well, and you're knocking it out of the park, and you're making all these sales. Well, your accounting systems have to keep up. You've got
Right.
to, if you're doing it yourself, it's worth knowing how to use QuickBooks. It's worth
Uh-huh.
knowing that you're doing it right, because there's nothing scarier than an audit.
Right.
So getting a good accountant on board, getting a bookkeeper on board early on, those are some of your, I think,
Right.
really good first expenditures on your business. So I see people get into trouble with that all the time. Um, from a legal perspective, people who don't form an entity or do it the wrong way form it, but they formed it through one of these document filing services and it just was done wrong. I've seen that. That happens. So making sure your entity is formed the right way early on,
Okay.
that's always a good thing too.
Well, good deal. So it sounds like it's one of those things. It's good to, speak to an attorney. I mean, at least if anything, you're giving yourself peace of mind that it's done correctly.
Right, exactly. And really, you just build it into your initial startup costs, right? So when you're putting together a budget, you're thinking about your web development and how much that's going to cost. You're thinking about what your, developing your packaging is going to cost and all that, and your brand identity. Just building a budget for a lawyer as well. It really, shouldn't cost all that much compared to everything else you're spending, to have a lawyer help you basically with some of the real, just the basic initial stuff, setting up an entity and maybe filing a trademark.
Okay. Good. Now, if someone had a limited budget, what would you say was more important to do first, the trademark or the entity?
Good question. I would lean towards the entity, because it
Okay.
will have the benefit of reducing your liability, which is sort of like a more of a survival element. So
Right.
I think that's a good thing to have in place first. And I don't want to underestimate the importance of, or understate the importance of a trademark. Trademark is really helpful to have, but in most cases, worst case scenario is you can tweak your brand or change it if you need to, if there's a problem. I mean, that's worst case scenario. No
Right.
one wants to do that, but you can tweak it if you need to, if you get a cease and desist letter. But much worse than facing a personal bankruptcy because you didn't form an entity and someone's house burned down.
Right. 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 That makes perfect sense. Okay. Well, good deal. I really appreciate the time you've taken here to share some, really good information. So if somebody wants to get a hold of you, what's the best way to contact you?
Sure. So I appreciate that. And I'd be happy to speak to anybody who has questions about starting an entity or protecting a brand, running an entity. Easiest way is probably through my website. So that's Stark, STARK, businesslaw.com. So yeah, feel free to find me through my website and I'm happy to speak.
Awesome. And I'll link to that in the description down below. So if anyone found this video to be helpful, please, feel free to leave a comment with any feedback you have, as well as giving us that little thumbs up. And if you've not already, please subscribe to this channel. So thank you again, Jared, for being here, and for everybody tuning in, so to speak. Have a great day.
Thank you.
Take care.